The following program has been pre-recorded, so please don't call in at this time. If you wish to participate in the program, tune in at 5 p.m. every Wednesday for A Pause for Thought on Baton Rouge Community Radio. Good evening, fellow humans. This is Wayne Parker with A Pause for Thought here on Baton Rouge Community Radio, 96.9 FM here in Baton Rouge. Well, thank you all for being here tonight. I'd like to remind everybody that this is a live call-in show. Feel free to call in and share your thoughts, questions, challenges, 343-9927, 343-9927. And our topic for tonight is felon disenfranchisement. The practice of banning people who are convicted of felonies from voting for various periods of time and for various reasons throughout the United States. And with us tonight we have Brian Marks, who is the head of WHYR's programming committee.
That's me.
Correct? And
hi, Wayne.
hello. And we may be having a call-in from Mr. Norris Henderson, who is the executive director of Voice of the Experienced, or VOTE, which has just worked with the advancement process here in Louisiana to challenge Louisiana's practice as unconstitutional of forbidding felons to vote if they're out of prison but still on probation or parole. Is that correct?
That's right. We're hoping to hear from Mr. Henderson, who's going to be calling in from New Orleans. He's the executive director of a prison reform organization. Mr. Henderson was wrongly convicted and exonerated. He spent several decades in Louisiana State Prison and is a self-taught lawyer. And his organization is the plaintiff in the appropriately titled Vote versus Louisiana. That's a pretty good name for a court case about this. Suing the state in state Supreme Court, which is an ongoing piece of litigation, about the argument that the state defines your right to vote being stopped if you are under a sentence of imprisonment for a felony. But the state is enforcing this for people who are on parole, out of prison, and people who are out of parole, out of prison, and just on probation. And the challenge is, in the court, that they are arguing the state constitution did not define what a sentence of imprisonment was, that when this was passed in the 1973 state constitution, it was intended to only mean while you were still in prison. And it's being enforced in the state to bar 2 times, double the number of people are not allowed to vote in the state of Louisiana. They're out of prison, they're on probation or on parole, relative to the people who are in prison. About 100,000 people don't have the right to vote in Louisiana who are otherwise eligible because of a felony, former felony or current felony conviction.
Right, and as I understand it, nationwide, it's a little over 6 million people now are disenfranchised.
That's correct.
But of course, the different states have different laws. Let's talk a little bit about the history of these laws, though. I was under the impression, before getting ready for the show, that most of the laws, the idea for the laws was created here in the United States for unsavory reasons, but actually it's an old practice. Reading from an essay here by George Brooks for the Fordham Urban Law Journal in 2005, where he states that the early origins of felon disenfranchisement has a long history going back to ancient Greece, and in Europe, medieval Europe, they called it civil death, basically. You could no longer participate in civil society. And these laws were brought over to America and established in the 1600s, and they normally dealt with things like drunkenness, immorality, things like that. And I can see where there could be some justification. If someone is habitually drunk, he probably isn't responsible enough to be leading or voting. You know, I understand it's not all that, doesn't sound all that serious to me, but nevertheless. But anyway, these go way back when, and most of the states established them after the United States became a country. And then we had the Civil War, or the war between the states. And that's where things changed drastically, I believe, because up until then, of course, it was easy to keep a certain segment of humanity in this country sidelined from all participation. But then the Civil War amendments to the Constitution, particularly the 14th and 15th, not only granted the right to African Americans to vote, but set certain conditions to make sure that would happen. And that upset a lot of people, of course. In fact, I know there was one leader in South Carolina that complained that they needed to do something to limit the black vote to prevent the white people from being overrun at the ballot box, basically.
Well, if you remember, I mean, Louisiana is still 30 to 33% African American in terms of our population. At the time of the Civil War, Louisiana, Mississippi, and South Carolina were majority black states. And of course, under slavery, not only were black people not allowed to vote, they were not considered American citizens. Under the Three-Fifths Compromise, their existence was used to give more power in the Electoral College and in the Congress to their owners. And of course, we abolish all of that with the Civil War and the 13th, 14th, and 15th Amendments, raising the question of black political power in the South for the first time, which is when felon disenfranchisement comes to the fore.
Yes, and something I thought of too, Brian. They wouldn't allow blacks to learn to read during slavery. Would darn sure not give them access to firearms, and all because the whites were so terribly outnumbered. They didn't want to give the black people any access to power, and of course this would follow with politics too once they were given the vote. And like you were saying, your last point.
Felon disenfranchisement. It comes about immediately in the wake of the granting of citizenship and suffrage to black men in the South.
Okay. Yeah, and of course, there are a lot of different ways that states handle this. Some are very restrictive. Some are very restrictive. Some are fairly lenient. Pardon me for my distraction there. For instance, Alabama, their laws are set up to where individuals convicted of a felony are ineligible to vote while incarcerated on parole or on probation. Voting rights restoration. Hang on a second. We got a call coming in. Let's see what's up here. Good. I think we got our facts. Anyway, technical problems here. Okay. Good evening. You're on the air with the Pause for Thought. Mr. Henderson, thank you for calling. We were just talking about you. This is Wayne Parker with a Pause for Thought. Brian Marks is here.
Good evening, sir.
And let's see, we did mention that you are the executive director of Voice of the Experienced, or VOTE, which has been involved in filing a case with the Louisiana Supreme Court regarding our felon disenfranchisement here in Louisiana. We've just been discussing the history of disenfranchisement laws and how right after construction they were expanded to do everything possible to limit the political participation of African Americans in this country. And if you'd like to take it from there, or just let us know what you're doing, and we'll just ask questions from that.
Yes, that's pretty much what the premise of the lawsuit is about. In 1974, when the Constitution of 1974 that became effective in 1975, did not deprive folks who had been formerly incarcerated of their right to vote. 2 years later, the legislature defined the term under orders of imprisonment to mean people that was on probation and parole, who was actually living in the community, paying taxes, and doing the things they need to be successful.
Okay. Well, I was going to clarify that, though. Okay, so these people are living in the communities now. They're on probation or parole. They're taking part in their community. They're working. They're paying taxes. And you're saying the legislature at that point still forbade them, or decided to forbid them, to vote at that point even?
Yes. And
Okay.
so our argument is that that's taxation without representation, because you're taxing folks, but you're still not giving them an opportunity to select members in their community that they live in to represent them. And so the lawsuit is pretty much based upon those 6 words under what order of imprisonment means. And when you look at the plain language of that, if you would just ask the regular citizen what their understanding of under order of imprisonment means, they would literally say that we're talking about somebody that's in jail. And so for the legislature, this legislation was passed by electorate of over 600,000 people in the 70s, and within less than 2 years, 144 people decided to change it.
Okay.
And so that's been our challenge.
Okay, and I haven't read that article in the Constitution, but you're saying that it's specified in prison?
It specifies, the Constitution actually says that everybody has the right to vote unless they're interdicted or under order of imprisonment.
Under
an order of imprisonment.
Oh, right, okay, under an order of imprisonment, right. And being out in the community working is not imprisoned. I can go
Exactly.
along. I can see that.
Exactly.
Yeah.
Exactly.
And
So, go ahead.
well, no, I was just thinking that from the little bit of research I was able to do getting ready for this, this sounds to me like the legislature expanded the law to allow disenfranchisement of more felons in much the same way that was done with the so-called moral turpitude argument in so many states, which
Right.
pretty much...
Alabama and Georgia.
Right. Which, and they didn't bother defining what moral turpitude was, so that was up to the local registrars and everything, and they could therefore use any excuse to, to bar somebody from voting.
Right.
Okay, so yeah, it sounds like it was motivated by the same kind of thing, to limit a certain segment of the population from voting.
Right, and if you check the history of felon disenfranchisement, it has nothing to do. There's no direct correlation between the person going to prison and their right to vote. None whatsoever. No judge ever sentences anybody that I'm sending you to prison for theft of an automobile, and by the way, you lose your right to vote.
Yeah.
No judge sentences anybody to that. And so, the argument that folks make is that, well, when you go to prison, because they got people even to this day that think they're disenfranchised for life, primarily because of what the various laws across the country. Some states folks lose the franchise forever, Florida, other places across the South. But in most cases, most folks, once they return to the community, that right is restored. That's an inalienable right. That's a right that you never lose. You're a citizen of this country. So how can you lose your right to vote if you're still a citizen of this country? Because the other thing is, if you're not considered a citizen of this country, then what are you?
Right. And really, I have to agree with you, Mr. Henderson. Where is the justification? What happens when a person commits a felony? Do they suddenly become incompetent to vote? Do they, does something change with them? So what's the justification for not allowing them to vote?
Exactly. And that's one of the real challenges that when you study the history of voting here in this country, at one time, the only people who could vote in this country were white men.
Right.
And then they finally gave something to other people. But it's been white men who have determined who can participate in this process and who can't. And then after emancipation, when people of color actually got the right to vote, especially across the South, they had more elected officials across the South, people of color, than anywhere else in the country. And then all of a sudden,
okay, Mr. Henderson, are you shuffling papers or something?
No, I was walking.
Oh, okay.
I was walking.
All right, yeah, there was a lot of scuffing noise and everything, and we couldn't hear you.
Yeah, I was just walking. But no, so that became the real challenge in the sense of especially southern states started going back trying to figure out how can we take the franchise back from people. And so they start creating all of these criminalizing everything. We started criminalizing things that folks in these communities were doing. They were like loitering, malingering. You go to jail for that. Like I said again, moral turpitude. And they defined what moral turpitude was. And so they were able to disenfranchise, for decades, thousands of people. Here in Louisiana, we have a population of over 70,000 people that has been disenfranchised here. So we're trying to get the franchise back for those folks so they can participate in the democratic process.
Right. Okay. Go ahead, Ryan.
I wanted to ask you, sir, what's the status right now of the case, Vote versus Louisiana? And if you can speak a little bit to, you've tried a legislative solution through the state legislature. What's the reaction been within the state legislature to your efforts?
Well, we had the bill filed several years in a row, because we only get off against sessions. And all the subsequent sessions we've had the bill that has been filed. And one of the things with that is we got the bill in committee and couldn't get the bill out of committee for several years. Then year before last, we got the bill out of committee, but when it came out of committee, got to the House floor, it was defeated down partisan lines. And so each year we make one step closer, and then we get a hiccup. One step closer, then there's a hiccup. And so the last time, the closer we've gotten in the legislature was that they offered to, while the bill was on the House floor, they wanted to amend the bill to put a prohibition, that they want to extend that to 5 years. I said, well, the people's already been out. Some people's been out since 1975. Why you want to extend it for 5 more additional years? But this was leading up to the last presidential election. So we was like, it don't have to be going into effect in August. We were willing to let it go into effect in January. To kind of like get away from the partisan politics. And it still fell along partisan lines. And so we decided then that we just going to have to file a lawsuit. We just have to file a lawsuit. The lawsuit now is pending in the First Circuit Court of Appeals. The trial judge, Judge Kelly, who even acknowledged in his ruling that this is wrong, but I have to follow what the law in front of me says. And so this is what we have right now. So we filed the appeal and waiting to, it's been docketed, so we're just waiting for a hearing date from the appellate court so we can do the oral argument.
Okay, when do you expect a decision on this, Mr. Henderson?
I would hope it would come, to me and to anybody who reads the plain language of it. It's simple. I don't see why it's really complicated. It's the interpretation of those 6 words. What all of imprisonment means. Does it mean the person in prison, or does it mean what they're saying, that the person that's on probation or parole is still convicted? Because the thing about the person on probation have never really went to jail. The person on probation got arrested, went to court, and got sent to probation and went home. And so that's not talking about a person that's under all of the incarceration, And I don't think that's the plain language from what the folks who voted on it. And, because the opposition is saying, well, this was the mindset of the people who crafted the language. But the people who voted on the language is what was their understanding of the meaning of those words.
In Louisiana, if you're on probation, is it also for a misdemeanor, not only for a felony, that you're disenfranchised?
Yes.
Ooh.
If you're on probation, period, you're disenfranchised.
I see.
And they don't distinguish between probation, between any offenses at all. It just says if you're under probation or parole, that you're prohibited from participating in the process.
I see. And once probation, prison, parole, all that's completed in the state of Louisiana, your voting rights are automatically restored? Do you have to appeal
Yeah.
to someone?
But you have to go to the registrar's office to get back on the rolls. But this last legislative session, to kind of like show you where all the confusion is at, this last legislative session is that they passed the law that the minute you get off of probation parole, that the Department of Corrections tickle the Secretary of State to put you back on the road. And so people kind of like see it, but nobody wants to really do anything to address it. And the real thing about it, even if the folks say that, okay, it applies to people on probation and parole, this is kind of like the more people are civically engaged, the least likely they are to recidivate. Florida did a study right after Bush v. Gore in 2000, and they gave the franchise back. They wanted a state that prohibited people for a lifetime from voting, and they gave the franchise back to over 30,000 people, and they've done a demographic study on those folks. And what they found was less than 10% of the people recidivated. Those folks who actually recidivated were for administrative sanctions. You know, I spent the night by my girlfriend's house and didn't have permission. I moved down the street without checking in. I lost my job and I didn't tell nobody. So for the most part, it helps, especially in a state like Louisiana where the recidivism rate is almost like 48, 49%. We need to be doing everything to help people avoid those pitfalls.
And just one last question for you, sir. Wayne may have some others. You, in your own personal story, I wanted to relate. You were wrongly convicted and of a crime, and how many years did you spend for which you've been exonerated?
27 years, 10 months, and 18 days.
For something you didn't do and you've been exonerated for?
Correct. I wasn't really exonerated. I came back to court, and the judge they gave me a new trial, and from that, I wanted to get out of prison, and so they gave me a probation, and I took the probation to get out of prison.
Okay, well, Mr. Henderson, we appreciate the work you're doing. We thank you for calling in here. I'd like to touch on a few more points with Brian here.
Okay, and we're going to let you go, sir, so we can possibly take some other callers. But if people are interested in finding out more about Voice of the Experienced, where can they find you?
Yeah, our website is www.vote-nola.org. That's vote-nola.org. If you want to contact me personally, my number is 504-453-4819.
Okay. Well, we sure appreciate it, Mr. Henderson. Thanks for calling.
You're welcome.
Okay. All right. Well, we got a little bit of insight there from someone who's actually spent time in the system and has been affected by this, and it's pretty consistent from what I've read, what he said. They just keep throwing one obstacle after another in the way of people that they want to isolate from the process. And it really is odd that they would give somebody probation and say, okay, you are fit to go out into public among the citizenry. You better get a job and pay your taxes, but you still aren't qualified to vote. It doesn't make sense, really. It just does not make sense. And what Mr. Henderson was saying, I think, is true. Louisiana specifies in the Constitution imprisonment. And if you're not in prison, then, if you're on probation, you're not in prison. But anyhow, before Mr. Henderson called, I wanted to talk about some of the different states. Maine and Vermont never take away the right to vote.
Yes, you can vote.
felons.
I think you vote by absentee ballot. I don't think they wheel the voting machine into the prison itself. But those two of the 48 states, you do not lose your right to vote for any reason related to imprisonment. You can vote from prison. And Maine and Vermont have not fallen off the face of the earth. They have survived. And in fact, they're much safer places to live than the state of Louisiana. And the people seem to do quite a lot better. So doesn't seem to have destroyed them.
No, in fact, I would suggest, just from what I've seen, that the more you do to prevent ex-convicts who get out from participating in productive society, the more likely they are to commit crimes in the future. I mean, I think it's been shown if you instead help them to get back into the community and be productive and participate and show them some respect, they tend to reciprocate and become decent citizens, or good citizens.
Sure. There are some things like, violent felons not having the right to own firearms and so forth. I think there's a public safety argument. I can see both sides of it, given the Second Amendment. But as the caller, as our guest said, it's absurd to make the deterrence argument that you're going to scare somebody from committing a felony because you're going to take away their right to vote.
Yeah.
Most people who don't have any criminal record don't exercise the right to vote. We had 13% voter turnout for the state treasurer's race. So there's that issue. And, of course, you can't say, because they will deny it, if you say you're engaging in felon disenfranchisement policies to disenfranchise blacks and African Americans and Hispanics and Democrats in order to win elections. They will deny that, I'm sure. But that's absolutely, and they admitted it back in the 1870s and 1880s and 1890s, why this began in the South. And if you look at the states, it's the blue states that have the least felon disenfranchisement in the North and the East and the West Coast. And it's down here in the Deep South that we've got the most restrictive disenfranchisement laws in the country, and I don't think that's a coincidence.
Yes, and many other people don't either. From what I've read, the Republican Party came right out and said it. About looking at it from the opposite direction, the Republicans were the ones that were freeing the slaves and for freedom, and they were all for giving blacks the right to vote because it would benefit them. And so,
absolutely. And
the flips, I mean, they had no problem admitting that. And from the one study I read, but
the parties have flipped sides in the South.
Yes, but I mean,
the Democratic Party, of course, in the 1890s was the party that wrote all these laws. But they're not the same Democratic Party that they are in 2017.
No, but the point I was making, Brian, is that the one side that is going to benefit from it was free in admitting it would benefit them. By the same token, the other side, they were also actually quite out there admitting that they wanted to restrict their voting to protect themselves.
Yeah.
So
the partisan implications of this in some places are not that big. In some places they might be quite large. In Florida, which is the most disenfranchised state in the Union, and of course also 27 electoral votes, if I remember, and a swing state, it could change who's the president if they were to change this. And this has become aggressively politicized and partisan. In Virginia, the Democratic governor, by proclamation, re-enfranchised 200,000 felons, and he's a Democrat. And that's been fought very hard by the Republicans in that state. Right now in Alabama, they are trying to smear the Democratic challenger for the U.S. Senate race by declaring that he is trying, with quote-unquote George Soros support and various other scare words, to re-enfranchise murderers and rapists and so forth. I think that's what you call a dog whistle attack, and trying to make this into a scare tactic against people. People, of course, can think what they want to think about it, but the partisan implications are potentially quite serious. 6 million people across the country disenfranchised in many states that are swing states, and there is a partisan bias in terms of who is being disenfranchised. Those people do tend to lean Democratic.
Yep, and But, as far as throwing extra barriers in the way, you mentioned Alabama, and I'm looking at an article here by Kira Lerner, and didn't get the publication it was with. But anyways,
okay.
It's about Alabama restoring voting rights to thousands of former felons, and it states that in May of 2017, this year, Governor Kay Ivey signed a bill that defined the term moral turpitude. And, of course, by defining it, that means they can no longer fudge it to mean anything to suit themselves.
Yes.
But
it can no longer become the modern version of the how many jelly beans are in this jelly bean jar,
right,
or how many soap bubbles are in this bar of soap, which they used to use to keep people from registering to vote.
Really? How about that? Anyway, but okay, so they made this step forward, and Mr. Henderson mentioned that. But then the Secretary of State, John Merrill, stepped in and said, well, I'm not going to dedicate any resources to educating people about that change. I'm not going to tell anybody.
Mm-hmm.
And to Louisiana's, credit anyway, when they loosened up their, I think, did they loosen them up? At least they came out and said that when felons are given their rights back to vote, the state has to notify them through the Department of Corrections. Yeah, Department
of Public Safety.
Yeah, Public Safety, yeah.
Our guest spoke a little bit about that. My understanding is the legislature in 2008 passed some legislation that requires notification of the restoration of voting rights, which, as he said, it's not entirely automatic. You have to basically have to re-register.
Right, yeah, but they do notify you that you can go back and re-register and become a voter. Okay, that's it, ladies and gentlemen. You've been listening to Wayne Parker and Brian Marks on A Pause for Thought on felon disenfranchisement. We didn't get to all the things we wanted to, but there you go. We thank you for listening. You have a good night. We got to go.